the Honorable Attorney General, the Learned Deputy, His Honor, the Chief Magistrate and Resident Magistrate, the President of the Bar Council of the TCI and the Doyen of the Bar, registrars, members of the bar, staff of the judiciary, members of the CAJO attending, and all attendees. I am Antonio Emmanuel, Secretary to the JEI Committee, and it is my pleasure to welcome you all to the opening ceremony of JEI Week 2023 and to our first seminar. As a matter of housekeeping, please note that our first seminar will immediately follow the opening ceremony, and our esteemed presenters have asked that any questions which may arise during the presentation be placed in the chat. And at the end of the 3 back-to-back presentations, they will be answered and discussed. I now hand you over to Ms. Monique Harvey, who will lead us through. Ms. Harvey.
Thank you. Thank you, Mr. Emmanuel. May we bow our heads, please? We have gathered here to ask the Lord's blessings and guidance as we commence Judicial Education Week 2023. Heavenly Father, we thank you for wisdom, knowledge, and understanding so that we as colleagues and participants may increase intellectually and further develop in our respective areas of our calling. We ask for clarity of thought and precision of speech as each presenter expounds the virtue of law and justice. Grant us the grace to endure, the patience to lend our ears, the courage to embrace each other in our various calling. We ask that you extend your grace and favor on our Honorable Chief Justice, Honorable Justices, heads of other civic departments and others present, our Honorable Magistrates and Honorable Chief Magistrate, Honorable Registrars and colleagues. And to this end, we thank you, Lord, in advance for a productive week as we join our hearts and minds together for the common goal, that is the betterment of ourselves and a reinvigorated environment. We pray in Jesus' name, amen.
Thank you so much, Ms. Harvey. I now hand you over to the Honorable Chief Justice, Mabel Ajaman, the Chairperson of the Judicial Education Institute of the Turks and Caicos Islands, for our opening address.
Thank you, Mr. Emmanuel. May I respectfully adopt the protocol set by Mr. Antonio Emmanuel, Secretary to the Judicial Education Committee, and wish you all a very good morning. The Judicial Education Week, which was established as part of the court calendar of the Judiciary of the Turks and Caicos Islands in 2021, is a festival of legal learning and practice. I trust that the judiciary and all our stakeholders will participate in this feast of ideas aimed at improving the work of the entire legal sector, justice delivery, and the application of best practices in law enforcement. I must express my appreciation to our stakeholders that for 3 years running, the JEI has received such good patronage. It is a testament to our collective desire and drive to continually improve our work by underpinning what we do with proper, current, and useful information. I thank all our stakeholders for joining hands to build an institute from scratch, to train not just our judicial officers and court staff, but also to provide training in needed areas for our stakeholders. We are grateful to our presenters and resource persons for accepting our invitation to impart knowledge and share learning with us on such a diverse array of topics. I'm happy to inform all participants that in our continued drive to entrench continuing judicial education, the judiciary is today launching our specialized website dedicated to legal learning. The website, which complements TCI Lee, may be accessed at jei.tc. It will be a repository of resource materials for judges, magistrates, lawyers, registrars, law enforcement officials, and persons carrying on quasi-judicial duties within the region and internationally. For this, I express my sincerest thanks to Mr. Andre Mills, Director of DETI of the Ministry of Finance, and his team, as well as our resourceful Judicial Education Committee Secretary, Mr. Antonio Emmanuel, for their efforts in creating a home dedicated to judicial and legal learning. We look forward to receiving your papers and articles on topics that will enhance learning for us all. We recognize the contributions of former members of the JEI Committee, former President of the Court of Appeal and Vice President of the JEI Committee, Justice Dennis Morrison, Justice Shiraz Aziz, former member of the JEI Committee, Ms. Aisha Defoe, former Secretary to the JEI Committee, and Resident Magistrate Carrie Ann Campbell, former member of the JEI Committee. I thank them all for their service to the JEI Committee. I celebrate the work of Mr. Antonio Emmanuel for putting this year's JEI week together in such a seamless fashion. Finally, I wish to thank all our stakeholders, and in particular, the Honorable Attorney General, the learned DPP, the President of the Bar Council, and the Doyen of the Bar for always joining hands with the judiciary in our initiatives. It is now my honor and privilege to declare JEI Week 2023 open and to introduce to you our first speakers. The Honorable Justice Vivian Georges Taylor Alexander of the Eastern Caribbean Supreme Court, the learned Mr. Eugene Otonya KC, Director of Public Prosecutions, and Dr. Angela Brooks, Deputy Director of Public Prosecutions. Respectfully, you have been provided with your bios this morning. Justice Taylor Alexander was chair of the committee that produced the criminal procedure rules for TCI. She worked with Justice Shiraz Aziz, Dr. Angela Brooks, and Mr. Oliver Smith KC. Their work, produced under great strain in the pandemic, is under review today on the topic 2 years on, a review of the criminal procedure rules. Thank you all for your attendance and for your attention. Antonio.
Good morning. Thank you, Your Ladyship. We now move directly into our feature presentation, 2 years on, a review of the criminal procedure rules. So I hand you over now to our presenters.
A pleasant good morning to all. Please allow me to adopt the protocol that has been established. And our presentation this morning will follow the format that I'm going to indicate. Myself, Dr. Angela Brooks, I am going to be making the first presentation, which is going to be an overview, a general overview of the CPR. I'm going to be followed by the Director of Public Prosecutions, Mr. Eugene Otonya KC, who's going to be speaking to the overriding objective. And finally, followed by Justice Taylor Alexander, and her presentation will be on how did we get here? What is the objective of the Turks and Caicos Islands judiciary? After which we will take questions, which we hope we will have time to respond to. Please allow me to now share my presentation. Can I please confirm with all attendees that my presentation is now being seen on screen?
Yes, Dr. Brooks.
That's it. Yes, Dr. Brooks.
Thank you very much. As indicated, my presentation will provide a general overview of the criminal procedure rules and will be expanded on by the learned DPPKC and by Justice Alexander. 2 years on, a review of the criminal procedure rules. The criminal procedure rules 2021 was made under Section 16 of the Supreme Court Ordinance and Section 74 Criminal Procedure Ordinance in Congress. The Chief Magistrate Court Ordinance was the first of its kind in the Turks and Caicos Islands. The rules are meant and was created and drafted to provide the necessary guidance, certainty, and quality to criminal justice delivery in the Turks and Caicos Islands. It was during the training sessions that the objective of the CPR was expanded on, which were essentially to develop a working knowledge of the criminal procedure rules, to promote and develop a practical application of the principles. It was during the training sessions that all the wrinkles and all the crinkles, questions and queries were asked and answered. And the training was deemed a success by all those who participated in such. Over the last 2-year period, as anticipated with any new legislation, there were teething pains because of the newness of the criminal procedure rules. And we as practitioners, having been, I would say, set in our ways for some time, we had to adapt and adjust to the new procedures, which were time sensitive in many instances. However, overall, we must extend ourselves some grace, as it has only been 2 years. Although the overriding objectives, which will be elaborated on by my director, has not been fully embraced, there has been a general adherence to the rules. And I believe as time progresses, our adoption and compliance with the CPR will be strengthened. The periodic review of the practical implementations of the CPR is imperative in fulfilling the overriding objective of such rules. How is the CPR working in the Turks and Caicos Islands? There are rules that have caused some debate as to the interpretation, and one of the areas, because my time is limited, that I will look at is bail. And if persons have their CPR with them, we can look briefly at Rule 13, persons remanded in custody. Rule 13.2 speaks to bail review being carried out prior to the expiration of the 6-month period for summary matters and the 9 period for indictable matters. This bail review has been, unfortunately, in some circumstances, interpreted as a bail application. Rule 13 is not to be used as a backdoor for bail applications. I can speak of experiences where we have been before the judges, and under Rule 13, we are supposed to be discussing the readiness of trials prior to the expiration of the 9-month period. In the Supreme Court, counsel have taken the opportunity to use this for bail applications. So this is not the intention of Section 13. And this has been one of the complaints from the Crown in regards to Section 13, Rule 13, sorry. I have noticed that this will be expanded on in Judge Taylor Alexander presentation. Rule 34, review of bail conditions of persons remanded in custody. Again, there have been instances where the defense have been using the rule to grant fresh applications for bail. Essentially, the rule is meant to review those persons who have been granted bail on conditions that they could not meet. It is not an opportunity to bring fresh bail applications before the court at that time. In considerations for review of the CPR rules, all applications for bail, with the exception of Rule 31(9), which is in the interest of justice, a court orders otherwise, defendants must follow the procedure set out in Rule 31. Most importantly, it must be in written, containing the relevant information that is set out in Rule 31(2). And once you have familiarized yourself with the rules, we would see what we are speaking to. Bail review, as captioned under Rule 13(2), can be considered for an amendment to read remand review. The hearing which have been taking place under 13(2) is to consider whether continued remand is justified since the speedy trial deadline of 9 months has not been met. For example, when a person is remanded on indictable offenses, the rules speak to the trial being heard within 9 months. Prior to the 9 months, a bail review, as it is now captioned, is heard before the 9 months is expired to ascertain whether or not the Crown and defense, if they are in a position to have the trial, if the trial is trial ready. If reasons the trial is not going to be ready within the 9 months period, his lordship or ladyship can then consider whether or not bail should be granted. So it is not a bail application per se. It is actually to ascertain the readiness of trial. So it is suggested, instead of the caption bail review, which can give the impression that it's a bail application or reviewing the bail conditions, we are suggesting that it can be recaptioned as remand review. Proceedings in the criminal court, and we're looking at Part 5, Rule 36. It does not appear that the orientation for the defendant is being conducted as indicated under this rule. However, the Vulnerable Witness Unit of the ODPP, with a standing approval from the Honorable Chief Justice, brings victims and witnesses especially vulnerable witnesses or witnesses, to the court for some familiarization tour of the court and its precincts before trial, advocating that Rule 36 be put into practice. Rule 37 creates a requirement for the prosecution to serve initial details of the prosecutor's case on defense, latest by the hearing in the magistrate court. This is not being fully complied with for various reasons. Rule 41B. What are the sanctions envisaged in this rule? Rule 49 Rule 49 sub 3. This rule, if utilized, can be very helpful. It gives the magistrate the power to commit a defendant charged with an indictable offense to an early guilty plea hearing instead of the sufficiency. This is being underutilized. However, given the provisions in the magistrate court's ordinance, which speaks to committal, it's clear that there's a mandatory sections that speaks to the rule. However, given the provisions in the magistrate court's ordinance, which speaks to committal, are so clear and mandatory that there is a concern that this rule may be in conflict with the relevant ordinance, because the ordinance speaks to having a sufficiency hearing, and it is time sensitive and it gives stipulated dates. So there's concern whether or not, if Rule 36.9 is actioned and implemented, is it then conflicting with the stipulations committing matters to the Supreme Court from the magistrate court? Finally, disclosure by the prosecution and defense. Rule 79 and Rule 80. Both the prosecution and the defense have obligations under the rules in regards to disclosure that must be more strictly adhered to. If the true spirit of the criminal procedure rules is to be realized, and that is to ensure that criminal cases are dealt with justly, both the prosecution and defense must adhere strictly to Rules 79 and Rule 80. In my conclusion, I would say that the implementation of the rules 2 years ago has been a breath of fresh air to all court users and the judiciary. However, in order to fully appreciate the smooth running of the judicial system, both prosecution and defense counsel must adhere to all the rules, the time restrictions, and appreciate the true spirit in which the rules were created. Thank you very much, and I'll now pass you over to my director, Mr. Eugene Otonye, KC, who will be making a presentation on the overriding objectives of the criminal procedure rules, and he will be followed by Justice Taylor Alexander.
Thank you, Dr. Brooks, for your presentation, and I will take it from there. I accept the protocol that have been established And I say good day to everyone. And to thank the JEI for slotting us in to deal with this very important topic, reviewing the criminal procedure rules 2 years on. I want to share my presentation now. And I hope it comes on. Right. So this morning, I have the task of focusing on a very critical portion of the criminal procedure rules. I think I would rather call it the soul, the heart, and the spirit of the criminal procedure rules. The overriding objective, which is a common denominator to all the rules that are grounded or underpinned by Justice Wolf's reform. And so this morning, I will speak on this as far as our criminal procedure rules 2 years going on is concerned. What is it? The overriding objective of the criminal procedure rules. It is provided in Rule 4.1, and I have added the word letter, the letter, and you will see the significance of that word, the letter, as we go on in my presentations. The overriding objective of these rules is to ensure that criminal cases are dealt with justly. Rule 4.2 describes what you may call what it means to deal with criminal matters justly. And it contemplates efficiency and expedition, fairness to prosecution and defense, interest of parties, witnesses, victims, jurors, and I must say all other participants as defined in the rule itself. Protection of the right of a defendant, assisting the court with relevant information, and looking at the nature of the case, its impact on defendant, and the other parties, proper and efficient allocation and use of resources. There's one striking thing about Rule 4 is the way it has apportioned duties to every participant, to every party, and that includes the court. And so it is very striking, it's quite remarkable, and leaving nothing to chance. And so Rule 4.3 then creates what you may call a general duty of all. And it is the duty of the court and all parties and participants at every stage of the proceedings to advance the overriding objective. Now, I think what is critical there again is what I underlined at every stage of the proceedings. I suppose the emphasis there is all at every stage of the proceedings to advance the overriding objective. And then on the screen, you will also see Rule 4.5, providing for specific duty for each party. And it says each party shall actively, underlining is mine, assist the court in fulfilling its duty under subrule 4, whether or not they have received any direction to that effect, and they themselves may apply for direction if needed. I think what is critical here is assisting the courts actively. Then you have specific duty to parties and participants. I'm not sure whether this is also part of the general duty, but out of an abundance of caution, the rule is making over provision for persons to know what they need to do to advance the overriding objective and to leave nothing to guesswork or doubt, even if it means repeating the provisions. But under the specific duty 4.6, the parties and participants are expected to prepare and conduct the case in accordance with the overriding objective, to comply with the rules and practice directions and orders of the court, and to promptly inform the court of any significant failure to comply with the rules above, and particularly complying with rules, practice, directions, and orders of the court. And it is interesting to know that you are role to inform the court promptly is irrespective of whether you are the person that is responsible for the significant failure. And so it then leaves all the parties to be involved at every stage of the proceedings, alert and pursuing one objective, irrespective of their separate interests, as it were, but pursuing one objective, and that is the overriding objective of the criminal procedure rules, advancing it with the sole purpose of ensuring that criminal matters or whatever matter they are dealing with before the court, they are dealt with justly. There is a specific duty for the court, and it is, excuse me, quite onerous because the rule use the word must seek to give effect to the overriding objective of the rules when they are interpreting or exercising their discretion under the rules or interpreting ordinance, rule, or practice direction. In other words, they must remember that the overriding objective is to give effect, seek to give effect as they do their balancing work in presiding over matters. They are also expected, that's why you have Rule 39.2 and Rule 41, Sub-Rule 1, through the actively managing the case and exercising the powers thereof. And so what I have just shared is probably what you may call the letter. And I was trying to find out, to find an appropriate wording or expression that can bring forth what I have been thinking in relation to the letter of the law and the spirit of the law. And I could only find an expression like the one I have on the screen, where Apostle Paul was talking to the Corinthians in the Bible, and the 2 Corinthians, he was saying, the letter of the law kills, but its spirit gives it life. I think what Paul is saying, by my respectful view, is that they should stop ticking the boxes in their observation of the law. technical observation of the law, it brings dead results. And I dare say, in our context, result that make a mockery of the justice. If I may repeat, I think Paul was saying, and if we bring it into what we are dealing with here, when we become too technical or take very technical posturing, looking just at the letter of the law and leaving the spirit, the result is usually dead. It's of no use to anybody, and it makes a mockery of justice. I believe that the spirit of the law and these rules is demonstrated in the practical application of the letter of the law with a genuine desire and commitment for justice, not only to be done, but to be seen to be done. That, in my view, is what the spirit of the law and of the rule is all about. And so it won't be a ticking of boxes. It will not be, okay, I am expected to file defendant's statement, I file it. And what you get in the defendant's statement does not in any way advance or help to crystallize the issues before the court. And what the defendant may say is, I have complied with the law. I have filed a statement called defendant's statement. I know that there are provisions under that rule that speaks about what it should contain. But our experience so far is I have filed my defendant's statement, and sometimes too, it's not even the defendant's statement, it is what triggers it. Because the defendant will say, I expect the prosecution to give me a written statement saying there is no material that could be considered as prejudicial or undermining the case of the Crown or assisting the case of the accused person. And so if I don't get it, I am not going to file any defendant's statement. And then I hear one of my colleagues also said to me, and that's why I'm so grateful for this opportunity we have in this JEI week this year to look at the rules again. Because he said to me, we are not going to give that statement because our duty of disclosure is continuous. Obviously, it doesn't stop you. You need to file that to trigger off the statement from the defendant. And then the obligation to disclose continue even after conviction. And we discussed that very briefly now. So I'm sorry, let me just bring down to where I was, sorry. Yeah, I was talking about the letter of the law kills, but the spirit gives life. The overriding objective, let's look at it. The overriding objective of the course duty. And in this section, I just want to highlight, as it were, the overriding objective in its letter and its spirit, as demonstrated in a couple of cases across the globe where Justice Wolf's triggered criminal procedural rules are in operation. The first duty of the courts in relation to the overriding objective, put in another way, is this: the court must drive the efficacy of the overriding objective through active case management. The court remains the driver, if I may say so. The parties will only assist, but the court will ensure and insist that it gets not just assistance, but an active assistance that advances the overriding objective. I think nothing less will do. And in that regard, I have the case of PC Sheldon Calendar and Kevon Neptune, where the Trinidad Court of Appeal has this to say: the essential ethos of criminal case management is that judicial officers must take more active and positive steps to direct and to ensure the quicker progression and determination of matters. And then in the case of JEI and others, or JEI, the Court of Appeal in UK had this to say: the sensible use of time requires judicial management and control. Actually, if I may read a little bit more of what was said in that case, the starting point is simple. The judges said, justice must be done. The defendant is entitled to a fair trial, and which is sometimes overlooked. The prosecution is equally entitled to a reasonable opportunity to present the evidence against the defendant. Resources are limited. The funding for courts and judges for prosecuting and the vast majority of defense lawyers is dependent on public money, for which there are many competing demands. Time itself is a resource, every day unnecessarily used, while the trial meanders sluggishly to its eventual conclusion, represents another day's stressful waiting for the remaining witnesses and the jurors in that particular trial. And no less important, continuing and increasing tension and worry for another defendant or defendants, some of whom are remanded in custody, and the witnesses in trials which are waiting their turn to be listed. And that's quite a sobering observation that they made. May I continue to say that the duty to ensure and to seek to ensure that effect is given to the overriding objective requires a robust, vigilant, and careful balancing. As the judge seeks to give effect, I believe this may probably be one of the hardest. I've not been a judge, but I can imagine all the competing interests that will be calling for the attention, and they need to balance it properly. And this is a case where the defendant or the appellant complained that he didn't receive a fair trial because the case appeared rushed. An application for adjournment to instruct a defendant expert was refused. And so he appealed on those grounds, alleging that it deprives him of fair trial. But the Court of Appeal took a very, by the time they finished analyzing what happened, the factual situation, and in the context of the regime we are in now, that is the criminal procedural rules that seek to do justice and the real justice. The Court of Appeal said the trial judge has always been responsible for managing the trial. That is one of his most important functions. To perform it, he has to be alert to the needs of everyone involved in the case. That obviously includes, but is not limited to, the interest of the defendant. It extends to the prosecution, the complainant, to every witness, whichever side is to call the witness, to the jury, and if the jury has not been sworn, to jurors in waiting. Finally, the judge should not overlook the community's interests, that justice should be done without unnecessary delay. A fair balance has to be struck between all these interests. But I need to say also that as the cases will show, that active management of the case does not mean unnecessary intervention in the presentation of the evidence of any of the parties in a way that also involves imposing of the view of the merits of the evidence as the judge saw it. And so in the case of Barry and A. Francis, the justices had this to say after not being comfortable with the way the judge had been a bit, overactive and overbearing in the matter, said, however, our system is adversarial, and it is a matter for the parties to present the evidence in the way which they consider best serves their case, subject to their obligation to further the overriding objective. They should be permitted to conduct and present the case to the jury without unnecessary interference. It is the responsibility of the judge, it seems to us, to assist the jury's task by seeking, at times, perhaps insisting on the orderly presentation of the evidence. It is, however, no part of the trial judge's task to intervene in the presentation of the evidence for the purpose or with the effect of imposing upon the trial their own view of the merits of that evidence. If he intervenes repeatedly to that effect, the danger exists that he will actually prevent a fair trial, or at least give the appearance of preventing a fair trial. In either event, the safety of any conviction may be in doubt. And then we move over to the overriding objective and the parties' duties. The parties must actively assist the judge, assist the court. And I use the word, excuse me, no more game playing. And I want to say that I didn't use that word, it didn't come out from me initially. I remember a case that was going on not too long ago. That case was supposed to schedule for about 2 weeks, or at most 2 weeks, but it eventually lasted for 5 weeks. But one of the witnesses that kept going, and every time he goes, he's told it's been adjourned. We don't even know in the trial one, we don't know when we can call you, but just keep coming because the way the case is going. And this witness, and up to today, I don't know who he is. I didn't want to find out. I just felt so bad because he got my phone and called me. And what he said was, Mr. DPP, will you guys stop playing with our lives, playing games with our lives? He just said that. And before I could respond to apologize or to find out what is going on, he hung up on me. And that is about game playing, he called it. But the case of Malcolm and the DPP spoke again about game playing. And that is the case where the judges the magistrates retired to consider their verdict and had announced their decision adverse to the prosecution on a point raised in the final speech by the defendant attorney. And the court, because it was being raised at that point, allowed the prosecution to open their case, and then to call a witness and evidence in relation to that point. And the appellant felt aggrieved and said it was wrong for the magistrates to allow the prosecution to call further evidence to meet that point as they did. They submitted that the magistrate had no such discretion under the rules, and that alternatively, they could not lawfully have exercised that discretion as they did. But the court refused and rejected that submission, and I have it there. Criminal trials are no longer to be treated as a game in which each move is final and any omission by the prosecution leads to its failure. It is the duty of the defense to make its defense and the issues raised clear to the prosecution and to the court at early stage. That duty is implicit in Rule 3.3 of the Criminal Procedure Rules of UK, which requires the parties actively to assist the exercise by the court of its case management powers, the exercise of which requires early identification of the real issues. And then if they went further, the Court of Appeal in Arrow and Gleason said it is understandable why, as a matter of tactics, a defendant might prefer to keep his case close to his chest, but that's not a valid reason for preventing a full and fair trial on the issues canvassed at the trial. The criminal trial is not a game under which a guilty defendant should be provided with a sporting chance. It is a search for truth in accordance with the twin principle that the prosecution must prove its case and that a defendant is not obliged to inculpate himself, the object being to convict the guilty and acquit the innocent, requiring a defendant to indicate in advance what he disputes about the prosecution's case offends neither of these principles. And then we have a homegrown case here, that is Caribbean, the Sexus case against the Attorney General of St. Lucia. And we know, I think most of us know, it's a matter that where they challenged the rule that requires them to give defendant statements. Obviously, as was expected of them to do at that time, they complained that it contravened their rights, the defendant's right to silence and self-incrimination and all of the ancillary rights that the Constitution had given to the defendant. Of course, it went all the way to Privy Council. And the interesting thing about this is that the Privy Council actually endorsed the utility of the defendant's statement. Far from compromising or undermining the right of the defendant to silence, which it did not or which it does not, the Privy Council said this: one, agreeing with the Court of Appeal to assist in the management of the trial by helping to identify the issues in dispute early. The defendant's statement also provides information that the prosecution needs to identify any material that should be disclosed to prompt reasonable lines of inquiry, whether they point to or away from the accused. It may lead to prosecution discontinuances and to prevent delay and lead to efficiency. And I remember one case that I mentioned to my deputy yesterday as we are going through this, a case of rape, and the issue was whether there was consent. We went on for almost 6 weeks in that case, only for the defendant to pull out the WhatsApp message and exchange with the victim. And it was obvious that that was it. And at that point, we couldn't proceed further with the case. But how is it? If the defendant had indicated to us, no, this is what I have, we probably, and I think we must have, we ought to, and we should have withdrawn that matter very early, saving everybody all the problem, all the tension and the stress, and of course, the resources that have been wasted. The second case that deals with the same issue of defendant's statement is a Trinidad case that we also know because it attacked the practice direction that the Honorable Chief Justice of Trinidad had issued. And Mr. Garth O'Brien was not pleased with that and went to court arguing and trying to distinguish it from Sexus and saying that the practice direction, to the extent that it provided what is probably detailed in the rules, but is not in the rules. To that extent, it was procedural and they ought not to have the strength of law and is null and void. A very beautiful judgment at the lower court there. I don't think it has gone further. I don't know whether it has, but the court has this to say: given the notorious backlog of criminal cases in our courts, the issuance of practice direction and the rules serve the public interest by instilling confidence in the administration of justice by convicting the guilty and acquitting the innocent in the shortest possible time. The requirement that an accused provide the facts on which he relies for his defense serves to strike a balance between the general need of the public to dispense with criminal cases in a timely manner and the personal rights of the individual. And then, of course, in Sheldon, that I mentioned before, this was a case that was thrown out because the prosecution represented by the police prosecutors, they kept absenting themselves, every time the matter was adjourned. And when it was ready for trial, I think it was in trial actually, but they never got on because the prosecution, one reason or the other, and the case was dismissed. And of course, they went on appeal, saying that the court did not, exercise its discretion properly. It ought not have, dismissed the case when they were ready to deal with the matter. On the last day, what happened was that the defendant lawyer was not present, but the defendant was prepared to go on, and the prosecution was not, about the 6th time by the court's record. And the court said, in order to facilitate the more expeditious sharing of matters, police complaints, and I think it also involves the prosecution, we are all tied up together, as partners in the criminal justice system, the police and the prosecution. And I think we are also there. We often play a central role, cannot allow matters to slide. For when this happens, a culture for unacceptable delay becomes endemic. And it is indeed has in this jurisdiction. And then the court lists what the prosecutors ought to do and expected to do, not only to be punctual and professional, attend court at all times, and if unable to do so, notify the court of unavailability and for reason of absence, adhere to directions given by the judicial officer presiding over the matter. Ensure the attendance of witnesses. Be prepared and familiar with the evidence and legal issues that may arise. Present the case in a clear, logical, and fair manner, and assist the court wherever necessary. This will facilitate administration of justice and ensure that aggrieved persons are not negatively affected by decisions to dismiss complaints for non-appearance of prosecutor or not being ready or the police. And in my conclusion, colleagues, I have this to say: buy-in is still needed. My colleague, the deputy director, had given a bit of where we are in terms of compliance. I think she had a note of optimism there. I still do also have my own note of optimism. And I think we are 2 years in the game. What we need is effective buy-in in relation to the overriding objective in particular. I want to say that from what we have experienced so far, 2 years, participants are not yet fully on board. We do not yet fully appreciate that if we fail to advance the overriding objective of the CPR, we fail woefully ourselves. We fail the community, which we serve, and we fail criminal justice. The hope that I have there is because although TCI is coming late in the game, we have a lot to learn and are actually learning from those who have gone ahead of us and who have treaded this path before us. The CPR globally has been there for more than 2 decades now, but here we are coming in just behind. But we have a lot, at least from the cases that we have looked at this morning, we have a lot to learn. And one other lesson is that the years of implementation of these rules across jurisdictions, including the UK, the home of Justice Wolf reforms, we have not yet come to perfection in achieving the overriding objective of the rules. May I say that I think from what I have read and researched, there is still growing pains and challenges. And that's the beauty and significance of the opportunity the JEI Week offers all of us to learn from each other as to what works and what does not work. And with that, I say thank you.
Thank you, Mr. DPP. I will continue with my presentation. May I ask that you take your presentation down from the shared screen?
Yes.
Yes, I would like, thank you. I would like to thank you and Dr. Brooks for your presentations, which has made the segue into mine so much easier. I want to thank the Honorable Chief Justice for inviting me back to TCI. I always enjoy coming and sharing my experiences from the jurisdiction in which I sit and our experience in using the criminal procedure rules, albeit not similar to the rules that you now have implemented in the Turks and Caicos Islands. I wanted to indicate that I had invited a senior practitioner from St. Lucia, Mr. Alberton Rishlow, to join the proceedings. In retrospect, I should have also invited the Director of Public Prosecutions of St. Lucia or a senior Crown Counsel from his office to ensure that there is that appearance of balance so that it is appreciated that the execution of the rules, as the learned DPP had pointed out, places obligations on all of us, the judicial officers, the defense counsel, and the Crown. And the overriding objective can only be realized when everyone has an appreciation of their function and recognizes that it is important that we are all to work together to achieve that objective so that we are, in fact, dispensing justice for the persons whom we are here to serve. I'm going to just put my presentation up on the screen. And so if you will bear with me shortly, and then I will begin my presentation. All right. Now, in preparation for the presentation this morning, I thought it would not assist the parties, or it would take too long, or not, it would be counterproductive for us to spend our time just going through the provisions of the rules again. We had done that 2 years ago, and we are now at a stage when the parties have developed a familiarity with the criminal procedure rules and have been able to identify those parts of the rules that work seamlessly, those that continue to present for them challenges, and those in their view that probably require some tweaking to ensure that the rules continue to remain relevant. And the learned DPP has in fact said that in the UK, their rules are reviewed quite frequently, and there is a purpose to this. It is to ensure that the rules continue to remain relevant, that they continue to address pressing concerns or concerns that arise in the presence of the courts, so that when the rules are utilized, they are utilized to address what are current concerns of the various territories. So in that regard, I have opted to focus on a number of choice areas in the rules that have been subject to litigation, that have been a subject of concern, or areas that simply need reiterating in order to ensure that the rules work effectively. Right. So what is the objective of the TCI judiciary? And recognizing that the rules are rules of court implemented by the Chief Justice in order to ensure that the proceedings in the criminal division work smoothly and address public interest and the rights of victims and defendants. Over the years, the workload of courts everywhere have increased at a greater rate than the resources that have been deployed for the courts. And because of that, many territories have experienced delays in discharging of cases. It therefore required a reformulation or back to basics approach as to what justice delivery is about. I think it was over 20 years ago, the Wolf reforms commenced in the United Kingdom, and the approach was to change criminal litigation in keeping with those reforms. It is not just to deal with cases justly, but also at a proportionate cost. And what does that involve? It involves us all being aware of the individual cases, their complexities, the issues, the witnesses or the parties necessary to litigate those issues, and as a consequence, to remove or to give less priority to those parts of the case that do not address those focal issues. The Wolf reforms have also prompted over all of the Commonwealth jurisdictions a recentering or refocusing on litigation that is litigant and victim focused. And I think I need to spend a little time just explaining that, especially for those of us in the Caribbean who come from very small jurisdictions. So we become, the lawyers, the Crown, the judges, we become very well known in the territories by the members of the society, and we are elevated and placed on this pedestal. And sometimes we allow that to determine our approach to our functions. We forget sometimes that it is about the persons whom we are to serve, because we become so immersed in our self-importance that it becomes about how we are seen, how we are perceived, the submissions that we advance, how intelligent we look. And that in that exercise, we forget the people whom we have been contracted and obligated to serve. The victims who have been waiting for a number of years for some element of justice, the defendants, some of whom are languishing in custody on the presumption of innocence until their guilt is established. And so the reforms aimed to recenter our approach to justice, reminding us that it is those parties who are to be elevated in the process, whilst we ensure that our role is to discharge that function that we have been contracted to do, to ensure that they are seen, that they are heard, that they receive justice. And so the rules developed the ethos, or is attempting to develop the ethos of the duty of every party and the court to be active participants in the management of cases. Now, what does active case management mean? One, it means that whereas before the parties would dictate the timelines, would dictate the pace at which matters proceeded to trial, the refocus is to ensure that the court now determines the progress of the cases. And it means, therefore, that the court has to be actively engaged to ensure that areas of delay are minimized or eliminated, that requests for adjournments are scrutinized very heavily, that insofar as the parties may not be prepared on any one day for a hearing, that the court is the one who takes them there and brings them into the issues at every hearing so that they are engaged in moving the case forward, disposing of issues in the cases that could be disposed of early, and where possible, disposing of the entire case even before trial. And that can only happen when parties are familiar with their files and familiar with their cases. So the obligation of the judicial officer is to ensure his or her familiarity with the case so that they can make sure that the parties are familiar with the cases and familiar with the issues that are to be litigated in the cases. So parties as well are required to prepare their cases and conduct their cases in keeping with that overriding objective. And if everyone is that way engaged from very early on, issues can be identified, dealt with, disposed of, or otherwise put on a path to allow the trial to proceed a lot more smoothly. The learned DPP in his submission indicated that at every hearing, and I cannot reiterate that position more clearly, case management takes place at every hearing despite the hearing that is coming on for determination. So at sufficiency hearing, there ought to be case management. And if a case can be concluded at the sufficiency hearing, that is the obligation of the parties. If the case is coming on for arraignment, it is not just arraignment. It is arraignment together with a review of the file to determine what can be dealt with at that hearing, disposed of and dealt with at that hearing. So the case management, I keep saying, is not an event. It is a mindset. It is a mindset that is adopted by everyone, not just practitioners, not just the court, but even the police officers and other persons, case managers, all persons who are involved in the discharge of justice. Because if the police officers understand their obligation, they would know that case files and disclosure have to be prepared early, because that will inform how the Crown proceeds. It will inform how the defense proceeds. That when the Crown receives the disclosure, if they appreciate that the first hearing involves case management, they will ensure that their files are served and not just sit back and say, oh, well, the police have not yet given me disclosure. If the matter is coming on for hearing and disclosure has not been received, get on the phone with the investigating officer. Where is that file? Why has it not been served? If you're having a challenge, how can we help you? So that the first hearing of the court is engaged in reviewing the disclosure, determining where the issues are, and what further disclosure or information is needed to address those issues. From the first hearing, the defense should be thinking of which witnesses are necessary to discharge the issues in dispute. The Crown should also be doing that, so that when the indictment is prepared, it is not simply an indictment identifying every witness who has given a statement in the case, but identifying witnesses that are necessary to prove what are the disputed facts in the case. So that is the type of preparation that is needed by the parties that is in keeping with the overriding objective. If that is done, there can be no challenge to any party identifying the disputed issues from very early in the case. What then is the intended outcome? It was an authority out of Trinidad and Tobago that indicated that the intended outcome of active case management is that there is proportionality, equality, economy, expedition, and fairness. I don't think I need to go into these. I think they're all explanatory, self-explanatory. And also, there is better engagement with the parties to litigation, that is the victims and the defendants, because after all, they are the ones whom we serve. Better engagement and better understanding by the parties impacted by the trials. Again, the learned DPP made reference to parties indicating that we, the players in the system, that's a word that is often used, the system, we, the players in the judicial system, in the dispensation of justice, we are playing games. And do you know why there is that perception? Again, because as we go about our functions of discharging justice, we have made it about ourselves. If we look at the setup of the courtroom, the bench elevated, the lawyers at the front of the court, and the parties and the victims somewhere to the side and back. And that is the perception that we have always had. We need to change that approach, elevate the parties, the defendants, the victims, and understand that our role is secondary to their interests, to their needs, to their issues. And once we appreciate that, there will be better engagement and therefore better understanding by the parties of their role in the trial. I have had cases where when the matter comes on for trial 5 and 6 years after, I have victims who have broken down in court and who have said that this is the first time in 5 years that they were contacted by the Crown to tell them that their case is coming on for trial. That in the last 5 years, they have had to spend time obtaining therapy, self-rehabilitating, as it were, due to the trauma that they have faced. I think we can do a lot better in reminding the parties that we are there to serve them, keeping them updated on the progress of the proceedings, and ensuring, and so far as possible, that they attend every hearing. We now have Zoom facilities. Even if our proceedings are in person, the Zoom can still be available to allow parties to join the proceedings, to observe what is going on, to be aware of where their proceedings are at. Yes, so that is how we, as the players, can ensure that the defendants and the victims are engaged in the process. But for the purposes of this hearing, I have chosen these areas of focus because, as I've indicated, those were the areas that, or those are the areas that have been subject to litigation, that have presented some challenges and perhaps just need some positive reinforcement. I am hoping that we will use the Q&A session very effectively to identify what other issues there may be and to see how we can address those. But I have, based on the reviews that I have obtained, focused my presentation on these areas. The first of which is the commencement date of trial, and I have termed it remand review, and for a reason. All right. Rule 13 of the criminal procedure rules of the Turks and Caicos Islands is engaged for the trial of persons on remand. That provision, and I don't know that I need to pull it up on the screen because I think we are familiar with it, but Rule 13 fixes a time by which a trial of a person remanded should commence. Now, for a summary matter in the magistrate's court, it gives an outer limit of 6 months. And for trials of on indictment of persons remanded, it gives an outer limit, I believe, of 9 months after arraignment. That provision allows for an extension of the time clock under certain circumstances. Now, I believe that this area has been the source of some confusion by the parties, a misuse, maybe deliberate or not. I would not think deliberate. I think it may simply be a misunderstanding of the provision of Section 13. But this rule, in my view, aims to ensure that Rule 4D and F of the overriding objective are considered in relation to a defendant who has been remanded in custody. That is, it ensures that his rights are always under consideration and that in prioritizing cases for trial, consideration is given to the rights of remanded persons because of the restrictions on their freedom. And this is done by reviewing the nature and the complexity of their case, the gravity of their offense, juxtaposing that with the needs of other cases, determining whether the defendant's remand continues without incident. All of that is the exercise that is performed by a judicial officer before determining whether there should be an extension of the time clock. The first obligation of the judicial officer, however, is to ensure that that matter is tried within the time frame fixed. The exception is the extension. So CPR 13 fixes that the standard that the court has set for itself for the disposal of cases of persons remanded. It, however, recognizes that there are circumstances where that time limit may be unachievable, and the trial of a case may commence after 6 months for a summary offense and after 9 months for an indictable offense. Where this occurs, the court is obliged to review the circumstances of detention of the defendant to determine if his remand in custody continues to be justified and whether the postponement of a trial is justified. Now, I wanted to address what the issues arising under that section are. The first of which is whether the appropriate terminology should be bail review or remand review. And I wanted to focus on a decision emanating out of your jurisdiction. And I noticed that Justice Baptiste is present this morning. Good morning, Justice Baptiste. A decision given by Justice Baptiste in Rex and Dale Extras. I thought Justice Baptiste was, as usual, erudite in his explanations, and I can do no further justice than to refer to the decision of Justice Baptiste in this case. So should the phrase bail review be more appropriately phrased remand review? And this was posited by the Crown in the case of Rex and Dale Extras. So as the view of the Crown that it would capture what is the actual intent of Rule 13.2, and it would distinguish it from bail review under Section 34 of the rules. Now, the judicial intent of Section 13 and 34, in my view, are clear upon their reading. They address different objectives. Section 13 fixes a time clock for the trial of persons held in custody on remand, and the court's obligation where the time clock is not met. And what is the court's obligation where the time clock is not met? While Section 34 requires a review of the status of persons who have been granted bail, but who have been unable to meet the conditions of bail. Justice Baptiste explained that distinction in Rex and Dale Extras. He explained it thus: although bail review appears in both Rule 34 and Rule 13, Sub-Rule 2, the bail review under these two rules cannot be conflated. The purpose of Rule 13.2, or the hearing on Rule 13.2, is to consider whether continued remand is justified, since the speedy trial deadline of 9 months is not met. Under Rule 13, Sub-Rule 2, the onus rests on the prosecution to satisfy the court that the custody order should continue and that the postponement of the trial is justified. It follows that if the prosecution provides justification for the continuation of the custody order and the postponement of the trial, the court may order that custody is to continue and adjourn the trial. The Rule 34 bail review is concerned with a person who has been granted bail, but is still remanded in custody due to inability to satisfy bail conditions. In that scenario, the court can vary the conditions of bail. As I've indicated, I thought Justice Baptiste's explanation of the two provisions was so very clear. But I wanted to suggest that for clarification and to avoid any misunderstanding, an amendment to Section 13 to remand a review can remove any perceived misunderstanding or misuse of the provision so that it reads more clearly and it is not confused with Section 34. The second issue is, how is the rule to be applied where the delay in the commencement of the trial is not attributable to the Crown? The rule assumes that the delay is attributable to the Crown when in fact a delay in trial can be attributable to the defense, or it can be administrative, the court's inability to try the matter at the time prescribed. Now, under the current regime, Section 41 on the court's case management powers can be utilized where the delay is not a Crown delay. Additionally, Section 15 of the rules can also be a fallback provision where the delay is attributable to an entity other than the Crown. Before I move on to Section 15, Section 41 allows the court to exercise its discretion to extend any timeline provided for in the rules. Section 15, as I indicated, is also a fallback position where the delay is attributable to an entity other than the Crown. So it provides that power to extend time in the absence of express provisions to the contrary in these rules or any other enactment. The court may, where it is considered in the interest of justice to do so, extend the time for doing any act under these rules. However, I would suggest that the optimal position may well be to amend the rule to reflect the circumstances that may result in a trial of a person on remand being delayed. And so a wording, for instance, to the effect that notwithstanding, in Section 13, notwithstanding a sub-rule 1, a trial may commence at a later date where a remand review is carried out prior to the expiry of 6 months for summary offenses and before the expiry of 9 months after arraignment for matters on indictment. And simply at B, the court concludes that a postponement of the trial is justified. And so under such a circumstance, submissions from the Crown, submissions from the defense can be entertained as to whether the postponement of a trial is justified. And I will, I suppose, when we have questions, hear your comment in relation to that. All right. I wanted, therefore, to focus on Rule 34 because that rule also featured in Rex and De Lex Charles. Rule 34 sorry, have I skipped? I believe I may have skipped a slide. Just bear with me. Sorry, I haven't. All right. Section 34, sorry, Rule 34, review of bail conditions of persons granted bail, but who are unable to satisfy the conditions of bail. And I believe that rubric is so self-explanatory that very little is needed by way of explanation. But the requirements under that provision is that a person must have been granted bail, that the person remains remanded, that a list containing such persons is to be prepared on the 15th of every month. And practically, I would imagine that that list would be prepared by the superintendent of prisons. And that list would be submitted to the court office and brought to the attention of a or the judicial officer. And the justification for that is to consider what, if any, conditions, as was reflected in the Alex charge, should be ameliorated so that person may take up their bail. Because the fact that bail had been considered and it had been determined that that person should have been granted bail, then it would be contrary to the order of the court to continue the remand of that person. But what should be considered is conditions that would be appropriate to allow bail to ensue. Now, there was an express concern that Rule 31(2)(b)(2), 31(2)(b)(2) of the rules, Rule 32 and 34, introduced opportunities for the rehearing and relitigation of, sorry, again, I've moved ahead of myself, so I do apologize, that Rule 31(2)(b)(2), Rule 32 and 34 introduced opportunities for the rehearing and relitigation of a hearing for bail where there is fresh legal argument, and that position is in violation of the common law position as is applicable in the Turks and Caicos Islands. And I thought I would give some background to the committee's thinking when the rules were drafted. And also what is the current position or the previous position, the background in the UK. In the United Kingdom, the common law position prior to 1988 was governed by Nottingham Justices and Davies. The legal position was based on a proposition that an earlier finding by a magistrate that circumstances existed for which bail was to be denied was to be treated like any other finding of a court, and that it was res judicata or analogous thereto, and it stood as a finding unless and until it was overturned on appeal, such that there could not be rehearings of applications for bail. In fact, there could have been a rehearing of an application for bail, but the magistrate was obliged to investigate only whether circumstances had changed. Now, in 1988, the Parliament of the United Kingdom enacted a Section 154 of the Criminal Justice Act, and that inserted Schedule 1 of the Bail Act to the Bail Act, and it inserted a new Part 2A, which clearly intended to change the pre-existing law so that a subject or a person should have the entitlement on 2 occasions to make arguments as to fact or law, even if on the first occasion he or she had advanced similar arguments. And that is the position in the United Kingdom. However, the TCI remains at the common law position pre-1988, because the Bail Act and Section 154 of the Criminal Justice Act are inapplicable to the Turks and Caicos, and it is the common law set out in Davies that continues to apply. When these current rules of practice and procedure, the criminal procedure rules, were being drafted, the committee was referred to a document entitled the Grant of Bail Policy Bill. And this weekend, I believe, again, it was the DPP who referred to the Chief Justice of the TCI as the great reformer. Again, it is a sentiment with which I concur. The intention of the Chief Justice was to ensure that that bill, that Parliament would have reviewed it with all expedition, and that it would have been assented to and promulgated into law almost in tandem with the Chief Justice's introduction of the criminal procedure rules. However, as usual, the court moved faster than Parliament has, and so that bill remains a bill, I believe. I'm not too sure what stage of the debate in Parliament it is at. And so that bill, the grant of bail policy bill, had in fact adopted the approach that had been taken in the United Kingdom, and certainly in many jurisdictions now across the Caribbean and the Commonwealth, to allow for second hearings at bail and reviews by the High Court sometimes of decisions of the magistrate as regards bail. But we are not there yet. And so the question and the discussion that I had with the learned DPP over the weekend, I believe it may have been Friday, Mr. DPP, I apologize, I'm not sure, is how do we approach the provision of the current rules of the TCI that have gone ahead of itself, because we do appreciate that these are rules and they are obviously secondary legislation to what the common law is. How this issue is to be resolved is a decision that has to be taken by the Chief Justice as to whether the operation of Rule 31(2) Sub-Rule 2 is suspended until the Bail Act is introduced, or whether it should be amended to be consistent with the common law position and then re-amended at whatever time that the Bail Act bill is introduced into law. Rule 33 of the CPR is similarly engaged on this issue. And so it will be a determination for the judiciary and the learned Chief Justice as to how that issue is resolved. But I thought background was necessary to explain why the provision read as it did. All right. The other provisions of, and based on whatever decision is taken by the Chief Justice, I imagine that the other provisions of Section 31, which are relevant and remain important, will continue to apply as they set out the procedure for how an application for bail is made. And I want to reiterate that because I think it is important that I also share that there is no model jurisdiction, and that in St. Lucia, the applications for bail, unless we have very diligent practitioners, will still be made orally, or there will still be an attempt to make the application orally. There will still be an attempt to file the application the morning of the hearing and to not supply any information in those applications that a judicial officer can rely on in order to make an informed decision. So for instance, there is usually a practice while the matter is still before the magistrate's court and disclosure has not yet been made in very serious matters to make an application for bail to the High Court, because our criminal code requires certain serious offenses that such application only be made to a judge of the High Court. So the application will come before a judge of the High Court with only the charge sheet. How is a judicial officer to make a determination about bail in relation to a serious offense concerning firearm, concerning murder, with only a charge sheet? And so that practice continues in our jurisdiction, despite us having the rules in effect for well over, I believe it is 10 years or more. And the rule being clear that applications for bail must be, not should be, not maybe, but must be in writing and containing relevant information that the judicial officer is able to make a determination for bail on. So I wanted to reiterate the Rule 31 and the provisions of Rule 31 that require the application to be in writing. And perhaps if we have taken anything from the presentation this morning, it is the importance of the overriding objective and the party's obligation to fulfill the overriding objective. Because if that is appreciated, then there is an understanding as to why the application for bail should be reduced to writing. And if we understood out of the presentations this morning that it is the rights of the defendants and the victims that are to be asserted, we will appreciate that if we do not make the applications for bail in a timely fashion, it will result in an adjournment. And if a defendant is on remand, any adjournment is critical to that defendant. And if we are to, in fact, actively manage cases and actively comply with the overriding objective, we will ensure that there is no unnecessary adjournment. So, reduce the application for bail to writing, provide all unnecessary information that the court would require to ensure that when the matter comes on for hearing, it is not adjourned and it is dealt with on that date. It is critically important that the bail application is also served on the Crown. Why? Because the Crown also has a fundamental obligation to put in their objection if they are objecting to bail, which objection, I want to reiterate, must also be in writing. And I reiterate that because it is a challenge that I face in my jurisdiction. I will have an application for bail before me that was filed 7 days before, 7 working days, served on the Crown, but it will come up before the court and the Crown will then make an oral application objecting to bail. And my question is, were you served with the application? Normal answer is, I'm not sure. And then defense counsel then will pull up their email showing where in fact the application was served and on whom it was served. Then the Crown would accept, all right, it may have been served. Can we get time to put in an opposition? Or, my lord or my lady, are you prepared to hear me orally on my objection? Well, my view is what's good for the goose must be good for the gander. And the assumption that my rules allow me to make is that if no opposition is filed, the Crown has no objection. And another statement I usually make to the Crown is that as a judicial officer, I do not work for the Crown. My obligation is to ensure the fairness of the proceedings. So don't expect me to use my discretion to determine whether I should grant bail or not without you advising me why I should not. If you have not filed your objection, I am to assume that you do not object. And if I am to consider the bail application, I will consider it based on what has been presented by the defense in their application. If the Crown wants to assert fairness, they must also be prepared to comply with their obligations under the rules. And not at the 12th hour, not on the last day, and simply file one document that says the Crown objects to bail. If you object to bail, why do you object to bail? And not just to state it, but to provide supporting documents. If you say a person is a flight risk, tell me why they are a flight risk. Not just because of the seriousness of the offense. What tells you? Because under our rules, despite the seriousness of the offense, under our code, despite the seriousness of the offense, our code says there is an entitlement to bail. So the seriousness of the offense by itself is not a justification to refuse bail. Or the assertion, of the seriousness of the offense is not enough for bail to be denied. So all parties must feed into the overriding objective, must assist the court in actively managing the cases. Do we now see the significance of this? So that the judicial officer can ensure that they have taken control of the proceedings and they are acting in the interest of all parties and the public. All right. The initial hearing and the initial hearing in the indictable offenses. And again, I asserted this provision because there was a concern that the early guilty plea provision under the rules was not being used effectively and may in fact be compromising the magistrate's ordinance on committal proceedings. As to the second, I disagree. An early guilty plea hearing would assume that it must be committal proceedings. What the identification of an early guilty plea does is it causes the judicial officer to ensure that very short timelines are given for a defendant who has said, I intend to plead guilty. So that, I don't want to say it's almost a reward, but because we are engaged to ensure that we allocate proportionate time to every case, if a defendant has indicated a particular posture, it is incumbent on the judicial officer that we move that case through the system expeditedly. So the early guilty plea hearing would be a hearing that is a committal proceeding hearing, where you do your sufficiency, where you assess the evidence, and then you list this matter for an early guilty plea. You encourage the Crown to have the indictment be prepared expeditedly, and that defendant is arraigned expeditedly. What has started in some cases here is that where there is an indication that the defendant is going to plead guilty, even at the sufficiency hearing, and that is a practice I know that has also taken place in the United Kingdom, the Crown comes with a draft indictment, so that we may well be able to, on that very day that we have sufficiency, have the indictment filed and have the defendant arraigned if he agrees to waive the time required by the rules and he's represented. That is what active case management is. Identifying where this case is at, where you know it's going to be going, and how can we reduce the time that is ordinarily spent taking it through its paces. So even at the initial hearing, the magistrate can identify, although indictable, the defendant has indicated he intends to plead guilty. Therefore, the case manager in the magistrate's court, rather than fixing the matter for 2 months down the road, fixes it a week down the road, encourages the Crown to ensure that the police have completed the disclosure and that within 1 week, this matter can be fixed for sufficiency hearing before the judicial officer. The judicial officer receiving the disclosure, seeing the note of the magistrate of the defendant's intention, hears the Crown and determines whether in fact the elements of the offense have been made out. And this is a matter that can properly be tried at the High Court before a jury or judge alone. Then conducts an inquiry with the defendant and his lawyer, or the defendant if he is self-represented, satisfy itself that the defendant understands the nature of the charge, understands what he means when he says he's pleading guilty, and if the judicial officer determines that all is in order, fixes the matter for arraignment, or if the Crown says, my lady, I have a draft indictment ready. If the defendant's lawyer says, we are prepared to enter a plea today if the indictment is filed, the matter can be stood down. The indictment filed. Come back, especially if we're not dealing with a very serious offense, so that we make sure that we make maximum use of the court's time. That is what the overriding objective and active case management requires us to do, always be engaged, and not that we are here for sufficiency. So let's go for sufficiency and let's leave that for down the road, because the time down the road can be used more effectively for a matter that is more complex, that requires our time and engagement. So that's just my suggestion as to how these matters can be dealt with. Otherwise, we can follow the timelines provided for in the rules and in the ordinance. But there is a discretion available to the judicial officer to keep the parties always engaged and always on their toes as to how can we deal with these matters more effectively and earlier. So I would suggest that that rule, Rule 49, is not in conflict with the Magistrates' Court ordinance. I'm also mindful of the time, and if I'm running over time, please tell me. I was only given half an hour and I can probably talk for longer. But I want to ensure that I focus on what are the narrow issues. All right. I wanted to address defense disclosure. Now, I almost thought that I need not do so because I think it has been spoken of and understood by persons. And this is an area that I believe it's not that it is not understood, but that the buy-in is not yet there. And perhaps I'm going to reiterate it just to ensure that we have the buy-in. And that is why I invited Learned Counsel, Mr. Albert and Richelieu, who in St. Lucia is one of these counsel who has been always diligent in preparing his defense statement and preparing it consistent with what the Criminal Code of St. Lucia and the rules require. And because of that, it has helped the court with its active case management of the issues and offenses in dispute. And perhaps I can start this by giving a story of what used to pertain in St. Lucia, and perhaps still does with some counsel. But, and before I do so, I wanted to go back to an issue of disclosure being late by the police. It was an issue that we were plagued with, and we are still plagued with it as well. But when I first came to the criminal division, I noticed that every time I had sufficiency hearing, all of the hearings had to be adjourned because there was no disclosure. And I said, I'm not having any of it. And it was always that the police officers had not yet disclosed the file. So our rules require that the police officer is and should be present at the sufficiency hearing. They never came. So I started issuing warrants for all of the police officers. It became, I became an enemy of the police, and I knew that, but my intention, my obligation was not to be friends with the police. It was to ensure that the parties, the litigants, got justice. And so warrants were being issued on a regular basis. The police decided that they were going to go on strike because since that lady came, things have been changing and she's not understanding. My obligation was not to understand. If there are problems in the police force, it has to be fixed to allow justice to be served. When the rules were being introduced, there was extensive consultation, even with the police, to ensure a timeline was fixed that was in keeping with the obligations of everybody. So mine was not to work for the police or to facilitate the police or facilitate the Crown, but to facilitate the expedition of justice. And so more and more as I issued warrants, we saw disclosure being done more effectively to the point now where that is no longer an issue. I can't remember the last time I issued a warrant for a police officer because it is more likely than not that the Crown has disclosure in their possession and have served it on the Crown, even if it is partial disclosure where, for instance, there are forensic reports outstanding, etc. Partial disclosure has been given so that the defense can start complying with their obligations under the rules. So I leave that story for then. Defense statement, we used to have the situation where we used to get one-liner defenses that the defendants take issue with the case filed by the Crown and puts the Crown to proof on all issues. How is that identifying the disputed issues? How is that allowing the court to actively manage cases? It did nothing. It did not help the court at all. And so we had engagement with the defense counsels. We reminded them of what the obligation was, that in general terms, to set out the nature of the accuser's defense, indicate the matters on which the accused takes issue with the prosecution, set out their case in such manner that allows the court to identify the disputed issues, and that defense should be signed by the defendant and the attorney. That way, a case management or immediately after the defense disclosure is filed, that the parties can then start looking more holistically at the case. Okay, if this is the issue, if the issue is self-defense, for instance, if the issue is that I was not there, do we need these witnesses? So that, for instance, let's assume that the offense is murder and the defense is self-defense, the assumption is that you are not challenging the medical reports. You are not challenging the fact that this person died by virtue of a gunshot wound or stab wounds, because your defense is self-defense. You're saying, I did this, and this is why I did it. So then, can the parties agree that perhaps the post-mortem report can be read into the record? Or if there are 1 or 2 questions that have to be put to the medical expert, can this be done by interrogatories and read into the record? Can the evidence of the expert be taken via Zoom, and can he be led so that we reduce the time that he or she is in court and the time that is utilized in the trial? We find out from before whether there intends to be any cross-examination on what issues, so that we are already beginning to identify the time that we are going to be utilizing a trial. If in fact it is self-defense, do we need Mr. Joe Bloggs from the corner who said, I saw Franz engaged in a fight with Mark and then take the knife and stab him in his chest? If his evidence is only that. If his evidence goes further to give some indication of what transpired immediately before and after, that's fine. But do we need his evidence if all his evidence does is to say that there was a stabbing, or that he came upon a body lying down on the ground with a knife in the chest or a gunshot wound? Those other witnesses, the fire officers who collected the body from the ground, do we need the evidence when they will say they collected the body from the ground and transported it to the hospital or to the mortuary? That evidence is not challenged. We do not need these witnesses. And so once we start engaging the parties, we now find that we have indictments that may have 13 and 14 witnesses being reduced to 8. And not only that, but after it is reduced to 8, then we then determine what aspects of the evidence are challenged. And those parts that are not challenged, can the Crown lead them on parts of the evidence? And we have that. A lot of our evidence of the police officers now, the officers are led in the evidence, because a lot of that evidence is not challenged. The charging process, if it was to be challenged, would have been challenged at an earlier stage of the hearing. If the defendant's rights were violated at the police station, we would have dealt with that pre-trial, insofar as it affected the fairness of the trial. But if in fact it does not, we can lead him. Did you prefer charge on that date? Did you read him his rights? Did you do this? So all the officer response is yes, 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 rather than have the officer come and say on the 15th of this month, whatever, I read the defendant his rights using the charge sheet used, a lot of which I find the jury shuts off on. When I watch and observe the jury during that evidence, they are not listening, but it is necessary to the trial. And so perhaps if we can lead those witnesses on that evidence, let's do so that we reduce our trial time. Let us focus the jury's mind on those issues that are relevant to determine the innocence or the guilt of the defendant.
Good afternoon, Your Ladyship.
Yes.
So as to facilitate questions.
My time?
Yes, you have, Your Ladyship.
All right. So I am coming to the end right now. In fact, I will move right to the end because that was where I intended to end.
Thank you, Your Ladyship.
And so my summary is this, that over the years, the workload of the court has increased at a greater rate than any increase in resources that have been made available to the courts. And this has led to delays in the discharge of cases. The rules place responsibility on the judicial officer to control and manage the cases, to ensure that it is the interest of the community and of the litigants that is promoted. So this responsibility is no longer left to be determined by the parties and their lawyers. However, the parties and the lawyers are enjoined to play a role in active management of these cases. I'm sorry I exceeded my time. I want to thank you. And so I believe we are now at the stage of questioning from participants present.
Yes, good afternoon, Ladyship. Thank you very much for that presentation. We'd now open the floor to all participants to questions. We'd ask that you please raise your hand in the chat so that we can select the persons in an orderly fashion. So anyone who has a question, please feel free to join in. Thank you very much.
I would want to assume it's because our presentations were so clear that there are no questions.
Or my lady, or even comments. Or comments.
And if there are none, perhaps just in the interim, I can ask Mr. Richlow if he's present very, very briefly to give the defense's perspective of how the rules have been functioning and whether they have been useful to the defendants whom he represents. Oh, I see there is a question. So let's probably take that question from a more,
We have a question from
Justice of
Justice
Appeal,
Rashid.
Ram. Yes.
Thank you.
Good afternoon, everyone. I take it is good afternoon where you are. It certainly is where I am, and I'm very sorry that I'm not camera ready today. But I got the link late, and when I realized that Justice Taylor Alexander, for whom I have the greatest regard, was speaking, I stayed on, and I thought, Judge, you made such an important point about the robust case management of the judicial officer. And I know you were tying it in with the magistrate's statute as well. But I wanted to ask you if you had to pick out one or two aspects of case management that you thought were vital to the discussion of eradicating delay in the criminal justice system, which, as we all know, is a serious issue. What would you, if you had to, what would you wish to highlight? And congratulations on your excellent paper, the parts of which I heard. I'm sorry I didn't hear your other two panelists. And congratulations to Mr. Emmanuel that I heard on, one of our former judicial counselor, the CCJ. Thank you, Judge.
Thank you, Justice Ramnath Lee. I don't know that I can identify one issue. What the approach that certainly I take is it's a roll up your sleeves type of thing at case management. Let's look at this file. And I believe we're at a stage now where the defense and Crown Counsel are engaged in that exercise. Let's look at this statement. Doesn't that statement require amendment? It contains some hearsay statements. We should probably remove that from now. What is the identified issue? And then to say to the Crown, if that is the identified issue, do you want to go back and revisit this issue? Do we need to go to trial with this issue? Is this a situation where if the defendant has admitted, for instance, so if I can give an example of a defendant who may be tried or who may have been indicted on burglary and handling of stolen goods. And it's not in every case where that would apply. But a defendant says, I didn't enter those premises, but I admit when I got those goods, the circumstances under which I got it, I knew that they were stolen. So he has admitted to handling of stolen goods. That is where sometimes the court can engage the parties. Mr. DPP, this is what the Crown is saying. There may be cases where you want to pursue the burglary, but given the type of sentence that handling will bring, given that we may address what the mischief is, would the Crown be interested in accepting the handling and perhaps nolly-processing on the burglary? You know, but it really is a hands-on going into the case file and saying, what about this? There is a gap here in this evidence. Your forensic evidence does not support the case that you are presenting. How are we going to deal with this? And by doing that, you get the counsels into reading their files assessing the issues and therefore determining if we go to trial, how do we go to trial, what are the issues for dispute? Mr. Richlow, do you want
Thank
to?
you so much, sir. Thank you,
Yes.
Judge.
Yes. Do you want to offer any comment?
Yes, please, my lady. In relation to the question of the defense statement, I believe that what has happened is that it was a kind of a culture that we did not want to adopt as soon as the rules came into effect. The culture that everybody was trying to keep their defense locked in their breast and take everyone by ambush. But then I realized when the rules came into existence, the rules came into existence with the objective of ensuring that no one is taken by ambush anymore. As a matter of fact, that is why that I always tried to have drafted my defense statements in accordance with the provisions as I saw them. So therefore, we identify the issues from as early as possible in terms of an active case management. So at the end of the day, if, say for instance, if my client is advancing the defense of self-defense, I would not just say, well, he's acting in self-defense, and so therefore I put the prosecution to strict proof that he was doing so and so, that he was not doing so and so. What I would do is point out the factual matrix within which, based on my client's instructions, juxtapose it against what the prosecution is advancing and place my defense statement within that kind of ambit. And so therefore, you would not have the problem of identifying exactly what the issues are, because the prosecution may very well be saying, well, from what he did, it appears to me that he just took the knife and he did so and so. But then my defense, in terms of preparing my defense statement, would be looking at the reality of the situation. For instance, a Palmer and the Queen situation, that the reasonableness you cannot balance it according to the niceties of the situation to say that, say, for instance, people are acting in slow motion and so I put out all the facts upon which I rely and say the reason why that my contention is that my defense is justified. And so I think it is a question, and this also, other than defense statements, your ladyship raised a very important point, especially in relation to bail. And Mr. Otonyo, the learned director, cited a very important case from Trinidad and Tobago. This is no longer a game-playing thing. Police officers allowed things to slide. And I have realized, say, for instance, when I'm making an application for bail here in St. Lucia, having regard to the respective provisions, say, for instance, the section 593.4, where I try to get as much information for my clients in the preparation of the bail. Say, for instance, the man's on the charge of murder, and he believes that he had a good defense of self-defense. The court will not be looking to a detailed account, but I am advancing that defense. But at least I would expect that the police would, knowing that, the police would make their disclosure as early as possible. So therefore, even at that point in time, that the active management of the application itself would assist the court in coming to a determination as to whether bail should be refused or granted. Of course, avoid the situation of persons having to be remanded in custody when at the end of the day, we do not know that that person may very well be acquitted. Let us assume he's acquitted, and the bail application was not made at an earlier time. He would have been remanded for the longest while in custody. And I've always remembered Sir Vincent Flosack, and I did not know if he had that in mind when he said, and it is important, that remand is only another fanciful name for imprisonment. And so at the end of the day, you might find him on remand for 10 years and then he's acquitted. What has happened to his life for the past 10 years if we have not done what we are supposed to do? And so in that regard, I've always welcomed that a lot of us practitioners should appreciate what is being sought to be achieved by a seamless working of the criminal procedure rules. Thank you.
Thank you very much, Mr. Richlow. Very well said.
I'm not sure if I'll be allowed to ask a question.
Yes, we have just about 3 more minutes for questions.
I joined late. Thank you very much, Mr. Registrar. Thank you very much, Madam Justice. late Alexander, Taylor Alexander. I although I was one of the persons who assisted in drafting the rules, I have some issues with some of the provisions in it, which are in my view not clearly spelled out and probably needs to be adjusted. The first one is, I'm not sure if that's addressed. The first one it's pretty obvious is that the rule speaks to indictment, and that creature is not known to the Turks and Caicos Islands, and I think there should be some amendment to either reflect information or some language to indicate that information also includes an indictment. But that's a quick fix.
So I believe that discussion had come up even in our committee stage, and I think
yes.
we had indicated that the dictionary should indicate that indictment includes information. I'm going to check it. I believe it is there.
I don't believe so, but I think it was planned to be there, but I'm not sure the reason why it didn't get in. But more substantively, the issue of the bail review, I'm not sure if that was dealt with because I said I joined late, is somewhat confusing. The situation with the prosecution is that they're advancing a theory that a bail review only applies if the person is on remand, as against if a person who was offered bail and was unable to take up that bail for lack of financial resources or lack of surety, etc. I think that needs to be clarified because that's a sticking ground constantly in that we face here when we have bail reviews.
Yes, we dealt with it earlier.
Very well, so I guess I was late. And the other issue I have is the certificate that the Crown would file indicating that disclosure is complete. I believe there should be some language that gives it a little more teeth, because in the last few cases that I've done, I've noticed that there is a failure to file the certificate of non-disclosure. Sometimes it's filed during the course of the trial. I have instances when that were filed, what is filed during the course of the trial, when the preferred norm is that is the document that would trigger the defense statement. And there seems to be no repercussions on these late filing. And, yes, you're caught, I wouldn't say ambush because that's a certain connotations, but you're caught off guard when there is a stream of notice of additional evidence that comes during the course of the trial. And sometimes it comes, if one may say, in a very cocktail fashion, in an attempt to address the evidence as it is being introduced before the jury or the trial fact. So those are the main concerns that I have, and I hopefully that there is some way of addressing those.
I think the Chief Justice is present, and on review and possible amendment of the rules, those issues may well be addressed. Mr. Smith, I do have taken note of it.
Thanks. And may I just say hello to Mr. Richard? I haven't seen him since we left Barbados.
I see.
Thank you. I believe we have time for one more question, and that's from Justice LaBon Jackson.
Good afternoon, everyone. I would firstly like to thank all the presenters who have done an excellent job in expounding on the CPR 2 years later. So I have a very quick comment and some observations. The quick comment is that I'm happy to report that in this jurisdiction, we do not have the issue of persons making applications that are not in writing. The converse is the usual course. The application is made to the court office in writing with notice to the prosecution, who normally responds in writing. And so the judicial officer is well aware beforehand what the issues are and is able to do fairness and justice to that application. However, there are areas of concern. We're not perfect and we're working on them. Notably is that there isn't, I believe, sufficient advantage taken of the opportunities given by the PDHs and the pretrial reviews. If the parties were to come to those well-prepared knowing, that these dates are not convenient for my witness, these are the issues, these things are still outstanding, we haven't completed the disclosure, but we have this particular timeline, or a particular report is outstanding, and this is why, and this is when we'll have it. That kind of preparation allows the judicial officer to make pertinent orders that are practical and helpful in moving the trial forward swiftly and avoiding delays. Because if persons come to the hearing and saying, oh yes, this date is fine, or witnesses will be available, and then in the middle of the trial you find that this one is on leave, this one is unavailable, we didn't know, it causes a problem. And so that the CPR allows, as Mr. Smith has indicated, the Crown to file a certificate that disclosure has been completed. So you don't expect to have any more disclosure in the middle of the trial. You would expect that the file is so well prepared, everything has been covered by disclosure. There are some judicial officers, including myself, who will indicate that if anything important comes outside of the period of the orders, that the sanction may be that the Crown will not be allowed to rely on them. And so that is the only sticking point. I would say that there is necessarily no fear of sanctions under the current regime. Parties will come and say, oh, we forgot, we're so sorry. But there seems to be a recognition that so far there has been no bite coming out of the rules. There has been no decision that causes everybody to, stand up straight and pay attention. But I believe that will come. Looking at where we are now, I would say that the rules have been useful. They've been very helpful in focusing all our minds, and we can make better use of it. So thank you all to the presenters, and 2 years in, I think the issues that have been identified are easily worked on.
Justice Jackson, I just wanted to say very quickly that if there is an appreciation and an understanding of the overriding objective, really, there would not be a need for sanctions, but we don't live in an ideal world.
Thank you so much to all our presenters. And thank you so much to all the attendees who have asked questions and for engaging with us. I'd now like to hand over to Ms. Tanya Okato, who would give a formal vote of thanks. And before I do so, I would share in the chat, it's a feedback survey to today's presentation, which we'd ask all persons to fill out so that we can improve future presentations. So without further ado, I'd hand over to Ms. Tanya Okato. Thank you.
Thank you, Antonio, and good afternoon, everyone. On behalf of the JEI of the TCI, we wish to thank all our presenters for today's session. Justice Taylor Alexander, your presentation certainly gave us food for thought and a better understanding of how we are to change our mindsets, specifically in reference to what needs to be done so that all involved can become more active in robust case management, which we understand to be paramount in ensuring justice and the dispensation of same. To the learned DPP, Mr. Utonia Casey, thank you for your presentation on the overriding objective and for helping us to understand the spirit and purpose of the overriding objective and the role that each sector plays in ensuring that the purpose of the overriding objective is met and that cases are dealt with justly and fairly. To Dr. Brooks, thank you for your informative session on the CPR and in particular as it relates to bail and bail review, which I am sure has no doubt provided further insight to those practitioners in the criminal field. To the Honorable Chief Justice, thank you for opening the week's session. To Mrs. Monique Harvey, thank you for your opening prayer and for blessing the week's activities. And finally, but by no means least, to all of today's attendees, we say thank you for attending the first day of our JEI week. and we hope to see you in all other sessions and seminars organized throughout the course of the week as we continue to celebrate this festival of legal learning. Once again, thank you to each and every one, and we hope to see you in our other sessions throughout the week. I now pass you back once again to Mr. Emmanuel, who is the Secretary of the JEI Committee.
Thank you very much, Ms. Cotto. And without further ado, that's the end of today's presentation. So again, we thank everyone and we look forward to seeing you all at our other presentations. Thank you very much for sharing your time with us. And we hope you have a good week, and we hope to see a lot of you, if not all of you, again throughout the week. Thank you very much, everyone.